the first to know in Nsem-Pii TV.
And the Supreme Court and Kyea a bedja ni nyina ne sɛ Atta lawyer Atta our counsel for boahen versus the states. Ɛde ɛyɛ judge a ɔdi case no ɛwɔ high court. Ɛde kɔ Supreme Court to say Supreme Court ɛnyi ne free court hɔ a yɛmma ne kwan sɛ ɔno na ɔbɛdi ɛyɛ boahen case no. Ne nyina ne sɛ or suspect say there is a collusion between Attorney General and the judge odi boahen case no, because he has seen on several occasions say Attorney General and the judge no ekɔ share ba bi no madum mu kɔma ɔmɛba court no no de asɛm foforo ɛna aba ɛna asɛm bia eji bɛka no ɛno na judge no edi so. Nkotie Eugene Osetutu na yentie lawyer Adom Ochre ento aso.
Omutimi am na ye inferior court no. Judge ne se chinchina opeso otena asem ne so. Ana touch answer yes enye de menti ase because akam na ketewa bi Supreme Court be rule umu judge you know wasem de da. Enti de enti na be se chinchina wotena asem ne so. But you see, it is coming from a certain place. Someone attaching a lawyer no. Ese judge no ti asem ne so na Justice Eugene Nyadu Nyante no. Omu nyinini. Again, request to be an so the more grant request for adjournment and so on so the case no expeditiously. Econonym. Intertaction and the lawyer no and then the client say, oh sharp papa no or your bias. I say on this state no prosecutor na na kra na bi pesa so mo pesa mo ye bibian tentem bi omutimi ko conclave ko cancel bi ono we defend the client no oni ho bi you be wan ne say prosecutors no every court oba every judge ne dem oba any ade enti ade ni se gidie nim. The summary of everything is that gidie nim. Now, right now, they come to Supreme Court. No, Paul will be in a better position to know these things. I don't watch on wire.
Seeks ambition against the High Court judge in the matter of the Republic versus Kwabena Dubois. And that's the way they say it in law. He's looking for an order to prohibit the judge from continuously sitting on his matter as a High Court, as a trial judge. They want the Lord Chief Justice to change the judge. If the panel of Supreme Court tomorrow were to agree with Atta, then the Lord Chief Justice will have a duty to remove the judge and place another person there so that the trial can continue. So what are the reasons that Kwabena Dubois is given or is asking for the courts to agree with him? Now, these are the summary of the reasons, and we'll go into the details in a minute. Reason number one, Kwabena Dubois and his lawyer said that the High Court judge has shown bias by holding court sittings with the prosecution present while Dubois was yet to be brought into the courtroom. They are alleging that. Two, they say the High Court judge has shown bias by insisting that he continues with the matter while there is a pending appeal against his decision. We'll explain this in some detail in the next page. And then number three, it says the High Court judge has shown bias by preventing Dubois from having access to important evidence needed for his defense. So the High Court, so they are saying that the High Court judge constituted court at 4:30 p.m. They were not aware. They were bundled into a car and sent to the court. By the time they got to the court, they saw the Deputy Attorney General and the Attorney General suggesting that these important prosecutors were aware and that they, the other side, were not aware. They believe that is offensive to the Criminal Procedure Act 30, I believe. The second one, they are saying that the High Court judge has shown bias by insisting that he continues. So normally when they bring an application before a High Court judge, he can have a decision on it. He makes his decision. If the parties don't like it, they go to the Court of Appeal or the Supreme Court for a review of that decision. Now, they're saying that whenever that happens, typically the judge must stay the proceedings and wait for the court, especially if they are saying that without this matter, we can't move on to defend ourselves. The judge says, I don't mind, go ahead and defend yourself. But if they sue, as they say, they sue upstairs and they're asking for a judicial review on the matter, typically the judge should hold. But they say that the judge says here, he says he's not willing to hold. Okay, so let's get into the details of the grounds. Ground one, which is ground one is the High Court judge has shown bias by holding court sittings at an odd time. This is the case. On 30th April 2025,
Get ready for a new look, new feel.
Jay Boahen, Charles Boahen, and Mildred Donko and their lawyers were invited to meet officials of the Economic and Organized Crime EOCO. But after a 2-hour wait, they were unexpectedly detained by armed EOCO personnel and taken to the High Court, despite protests from their lawyers, Samuel Atta and Kwame Osei-Asare and Peter Osei-Asamoah. They were ushered into General Jurisdiction Court 10, that's a courtroom, where the Attorney General and his deputy were already present. The lawyers, caught off guard and not formally dressed for court, were served with a charge sheet and prosecution facts that had been filed earlier the same day. In violation of legal procedure requiring prior notice, it will mean that the charges were filed and the court made aware and made to sit the exact same day. The presiding judge, His Lordship John Eugene Nyante Nyadu, proceeded with the arraignment despite objections, and the group exited the courtroom at about 4 p.m., at about 6 p.m. Now, Kwabena Boahen is saying that this is untoward, this is not part of the legal procedure. You don't surprise an accused person by asking him to come to an investigative agency, Yoko. He's at Yoko for 2 hours. He finishes, hey, come and sit in this car. He sits in the car, they are put in the car, and they are sent to a courtroom. Then the Attorney General is already there, the judge is there. It's past 4 o'clock, normal time for the court to close, but this judge was sitting, waiting for them, and then they served them with a charge sheet, etc., etc. So that's ground one. Ground two, that the lawyers of Edu Boahen filed an application praying the court for an order directed at the Attorney General to disclose all the pages of evidence required. This included some pages of a bank statement produced by the Attorney General, as well as evidence of certain procedures that are used by the national security architecture. The application was because some of the pages of the documents provided by the Attorney General as evidence against Edu Boahen had been deleted and could contain important evidence to prove his innocence. Further, the court's order for national security to disclose its procedures would have aided the defense, show the court that what Edu Boahen did was standard practice in national security architecture and was not theft. So on this one, the Attorney General brought a document to the court to prosecute Edu Boahen. It's a bank statement from one of the banks. Now, the bank statement has about 100 pages, but the observation was that about 90 pages were taken out, and the court didn't see it. It wasn't in it. So the Edu Boahen's lawyer says, but what's going on? You have a bank statement that has Edu Boahen's transactions. It's 100 pages. Put all there. We will show you what you are looking for. We'll show you how it works. But you have taken this substantial amount out and you are submitting to the court a few documents. I mean, if this is true, it's quite bizarre. If it's true, it's very, very bizarre. You are a defense person. They bring your bank statement and they've taken some out. How are you going to deal with that? Why should the prosecution be allowed to do that in a democracy and in a normal court practice? So they're arguing against that. That's not correct. I mean, if this is true, this is very serious. Also, they say that the things that you're accusing Kwabena Boahen for is a standard procedure of the national security architecture. Bring the national security people in. Let us ask them whether this is not their procedure. Whether in 1993 they didn't do the same thing. Whether in 2016 they didn't do the same thing. Whether in 2011 they didn't do the same thing. And then the prosecution says, no, I'm not going to do that. And they make an application to the judge. The judge says, I'm not going to allow you to do that. It is as if you want to tie his hands behind him and shoot at him. You don't want him to be able to defend himself, because the material that he's going to use to defend himself is within the bosom of the prosecution. Sometimes they call it discovery in legal practice. But Edu Boahen is complaining about this as a second ground. The third ground, Edu Boahen says that, okay, so on the second ground where they are not allowing him to defend himself, he's relying on a recent case of Republic versus Bafuboni, in which the current acting Chief Justice ruled as part of the matters, and it was said that they should allow the prosecution should give to the defense anything that the defense needs that will be needed for the evidence in aid of the defense case. Prosecution and the court should allow the defense to get everything that the defense needs, even if they have to get it from the prosecution, which will allow and aid the defense of his case. So Kwabena Boahen cites this as the reason why he thinks that the judge should comply and allow them to get the full document of the bank statement and also the national security procedures. They should bring them to the court. Now, on the third ground, he says that upon refusal by the court's order, the Attorney General to provide full disclosure, Edu Boahen's lawyers appealed the decision by the judge, insist on continuing. Edu Boahen appealed the decision by the judge. I appealed the decision, but the judge insists on continuing the trial despite a pending appeal before the Court of Appeal. This is all on the backdrop of the judge acceding to request to the Attorney General to deal with certain matters earlier than has been fixed for determination in the court. So this is very, very, very concerning. Here, Boahen's lawyers are saying that based on the fact that the judge says he will not allow them to get the full bank statement, they filed an appeal to the Court of Appeal, told the Court of Appeal that, look at this, we need this to defend ourselves, but the High Court judge says that we are not entitled to it. Now, whilst the Court of Appeal is preparing to hear the matter and give a decision one way or the other, the High Court is continuing with the trial, that whether you have it or not, I'm moving on, I'm going on with the trial. He may go on the trial and get to the end of the trial, whilst the Court of Appeal is yet to bring the decision down. So they are saying that, no, let's go to the Supreme Court and say that based on all of these demeanor findings, we believe that this judge should be prohibited from continuing to hear the matter. The Supreme Court hears the matter tomorrow morning. Good luck to all parties. But we hope that the democracy is built as a democracy. It's not built as a democracy of an oligarchy, or it's not built as a democracy of some feudal state. Democracy is democracy. Transparency is important. The judicial strength is important. People must have the right to defend themselves. All of those ethos guaranteed by the 1992 Constitution must be very important. If a person is guilty, he's guilty. But let's not be hearing these things from the court, and let's hope that these things are not true. The Supreme Court will have their decision to make tomorrow when all of these matters are brought before them. Let me take some text messages, and when I come back, we are getting to important matters. Okay, let me just hit on the LGBT, and then we can take some text messages. Moses Fuamonin is here, Sam George, the Speaker, and Mahama Yariga. Earlier today, Moses Fuamonin's coalition held a press conference, and they were quite straightforward. They said that if within 2 weeks they don't see where the thing is going, it's going to be a problem. Mahama Yariga's view of the matter is that the bill had died. Oh, sorry, the touch screen is going to come back here. Is it back? Mahama Yariga's view of the matter is that the bill had died in the 8th Parliament and a new one needs to be set up. The President also said the bill had died and a new one needs to be set up. People think that the bill has not died. I think there's a whole constitutional conversation on it. To the extent that the bill did not fulfill all the stages to become law, it will stand as having been killed by the 8th Parliament, because it has to complete its process to become law. Then it would have been a bill passed by the 8th Parliament. The 9th Parliament cannot pass something that was begun in the 8th Parliament. No Parliament can pass something begun in another Parliament. If a bill is begun in a Parliament and it doesn't see the light of day until the end of the life of that Parliament, on the 6th January, 4 years hence of the inception of that Parliament, then the bill dies naturally. So the Speaker has promised that they are going to set the bill again. In fact, Team Fojo has a new draft. And so they are preparing for it to go through the stages in Parliament, 1, 2, 3 readings in Parliament, with all the adjustments, perhaps a public hearing somewhere, and all the memoranda collected. It will be passed and it goes to President John Dramani Mahama. It is only then that the test for Mahama, whether he wants to sign the bill or not, will accrue. Up until now, there's nothing before the President's desk. But the coalition has started holding press conferences, and perhaps on Thursday we'll interview Moses Fuamonin about it. Also, another small matter. The bill, Sam George is preparing a bill to go to Parliament, the Cybersecurity Amendment Bill. That's very interesting. And in the Cybersecurity Amendment Bill, he's complaining, there are complaints that there's freedom of speech that is being tampered with. There's massive tampering of freedom of speech by the bill. We are going to check that. On Thursday, we'll come with a full analysis of the conversation. I've seen the video that Kojo Ponkroma has put up. We've been talking to him about the basis, and he's given us some education. Hopefully on Thursday, we'll get the full analysis of this bill matter. Okay, now it's 10 minutes to the top of our 11. Let's say, top of our 10 o'clock, let's take some text messages. And when we come back, we will hit right on the